Hi, I'm Jonas Urba. I'm a New York employment lawyer here with Employment Law Reality Check. Last week I did a video on how do we represent employees who we may never meet in person. How's that even done? And today I'm going to talk a little bit more about that. At this point, we've already reviewed some documents, we've discussed the issues with a potential client, and now we need to really get into what the defenses might be of the employer in any employment law case. Because defenses are very, very important, and you need to be able to address those up front before you even start filing complaints or filing charges. You really need to know what the employer's potential defenses are going to be and talk about those with your potential client. It's a lot easier when you have a position statement or you have a response to a complaint, but it's always important to talk about it as soon as possible with a potential client. And we dig a little bit deeper at this point also with the client, talking back and forth to see how will each of us handle the stresses of litigation. Some clients will call and they'll say, you know what, I know the employer is going to settle. I know that this is going to be a no-brainer. We're just going to be able to settle it, walk away. And we can never plan for that, because even a case that has the very, very best facts, an employer will always have a defense. And we don't plan on the fact that the case is just going to settle and we're all going to be able to avoid litigation. We have to prepare for litigation, have to know whether the client will be able to handle the stresses of litigation, because there's always going to be stresses with litigation, guaranteed. And so during this process, sort of this intermediary process that we go through, we're each trying to decide whether we're going to be able to work with one another, because it's going to take some time. And most employment cases, even if it's rocket fast, it's going to be probably 6 months before the final documents are signed and the entire case is wrapped up. At the soonest, it's 6 months. It could be years. And so you want to make sure that if you're going to sign up a client, you've established the rapport, you've gotten the facts, and you have a fairly decent idea of what the employer's defenses might be. They're probably going to change. The employers don't have to stick with the same defenses that they initially presented to the employee. They can always change. But we need to know what those defenses are going to be, and we need to try to address those at least with our own client right up front. We might even talk about what the client's expectations are. It's really important to know where your client is as far as what is it that their goal is. And this is sort of the phase where we're probably going to talk about that. But the most important for you, for the thing that you will want to do, is call some employment lawyers. Make sure you call around and talk to employment lawyers to see who you have the best rapport with, who you can actually talk to, and who you feel most comfortable discussing your case with. It's so important to call a lot of employment lawyers. You can call me. I'm Jonas Urba. I serve the entire state of New York, and I can be reached